Your reaction to the Alberta Court of Appeals ruling today?
Well, look, we obviously disagree with the decision. We feel that the Impact Assessment Act is tailored to touch only federal areas of jurisdiction that apply to certain projects. It is carefully meant to do that. It's important to protect those environmental aspects. It's important to protect Indigenous rights, for example, in these projects. We felt from the beginning that this act would result in better projects, better resource development projects where the community was more involved, where the environment was better protected, where Indigenous nations were involved from the get-go in terms of the process. We feel it's UNDRIP compliant as a statute. We've always cited it as UNDRIP compliant as a statute. And so we feel that it is very much in the spirit of cooperative federalism. It is very much in the spirit of good management and projects and protecting the environment. And we definitely feel it's within our jurisdiction.
Okay, I'm going to read, Minister, I'm sure you've read it, the court's decision. They do not hold back their language. This is a classic example of legislative creep, they say. They say that if upheld, the legislative scheme would allow the government to essentially render worthless the natural resources of individual provinces by stopping their development. It would permanently alter the division of powers and forever place provincial governments in an economic chokehold controlled by the federal government. Your response?
I disagree with all of that quite clearly. The environment has long been held to be an area of shared jurisdiction. Justice Laforêt said that in the Old Man River case, and that was reaffirmed by the Supreme Court of Canada in the carbon pricing case. It's an area of shared jurisdiction. The environment is something, environmental knowledge, environmental protection is something that has evolved since 1867. I don't want to freeze the Constitution in terms of the division of the actual, to include everything that might have been thought of in 1867. So it's very much a part of federal jurisdiction, shared jurisdiction. We've carefully tailored that act. And we feel that the jurisprudence goes against this decision. I would also point you to the very, very strong dissent in this decision by one of the justices.
By one justice.
Well, and it is compelling. It's compelling reading, and I would submit to you that both the language chosen in the decision and the reasoning in the decision is far more compelling, far more persuasive legally than that of the majority.
Right. The four judges say, in fact, that the environment like this is not protected by the Constitution. They say it's, quote, an existential threat. That's how they call it, an existential threat that is pressing and consequential to the division of powers guaranteed by the Constitution and thus to Canada itself. I'll read you one more part of this. They say, through this legislative scheme, Parliament has taken a wrecking ball to the constitutional right of citizens in Alberta and Saskatchewan and other provinces to have their natural resources developed. And then they say it's also discrimination. Again, these are hot terms. What is your response to this? And because it sounds like whatever you think, the federal government thinks, four members of the Alberta top court think this is discrimination, legislative creep, and it's clearly divisive.
Well, again, I disagree. We tailored the legislation to touch only federal areas of jurisdiction. We tailored a process that would be looked at carefully in terms of assessing projects. And we stuck to, as I said, we stuck to the areas that we feel are quite justified by the jurisprudence. Remember, this same court felt that the carbon pricing scheme was also unconstitutional, and that too was found to be not the prevailing interpretation by the Supreme Court of Canada. So I'm pretty confident moving forward that we have crafted a piece of legislation that serves Canadians, serves the environment, serves Albertans. It's not simply up to a province to determine all environmental aspects of a piece of, a particular project in its own provincial process when there may be spillover into other provinces, when it may touch upon areas of federal jurisdiction like protected species, for example, or Indigenous rights. And so we need to work together with the provinces, but certainly I would say to you that the kind of language that you see in the dissenting opinion, which is much more measured, I think would be indicative of how I feel about it.
Minister, the court argues, the majority, that this is a slippery slope. And let me just quote it again. Were the courts to uphold this law, all provincial industries, they write, every aspect of a province's economy would be subject to federal regulation. It would undermine the division of powers and permanently alter the division of powers and forever place provincial governments in this economic chokehold controlled by the federal government. Those are their words. Does this piece of legislation allow the federal government to take over other aspects of provincial jurisdiction? That's what the court's arguing, that it gives you too wide a berth. It's a slippery slope.
I disagree strongly with that interpretation. I guess I have to admit I don't like slippery slope arguments generally, but it only is in areas of federal jurisdiction. Canadian businesses, Canadians have lived with a division of powers, division between federal and provincial jurisdiction since 1867, and will continue to do that as the country evolves, as issues evolve, as challenges evolve, like the environment. That's the existential crisis here, and we need to work together moving forward to assess.
But they're
projects.
saying this is a. Yeah, I guess they're saying that the environment is being used to erode that power.